Does a 4-year delay between the commission of a rape and the indictment constitute a violation of a defendant's right to prompt prosecution? To find out, you have to read People v. Regan, but it's 47 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, Court of Appeals cases in 5 minutes or less, hopefully. This is the case of People v. Regan. This can be found at 2023 New York Slip Opinion 01353, published by the Court of Appeals on March 16th of 2023. There's a criminal case, and it relates to the constitutional right of prompt prosecution. And to appreciate and understand what's going on in this case, you have to understand two basic areas of the law. One is that in New York, there is a constitutional right to prompt prosecution. A defendant can't just be held in abeyance for 20 years before charges are brought. It's subject to dismissal on the basis that it's violated the constitutional right to prompt prosecution. And the second thing you have to understand is that when a court evaluates whether there's been a violation of that right, there's a 5-factor analysis called the Taranovich factors under the case of People v. Taranovich. And the 5 factors are considered holistically. No specific factor is determinative. And the 5 factors are, number 1, what's the extent of the delay? Number 2, what's the reason for the delay? Number 3, what's the nature of the underlying charge? Number 4, has there been a pretrial or pre-indictment incarceration? And number 5, has the defense been impaired or prejudiced by the delay? The facts here are that a victim, a female victim, went to a wedding. After the wedding, she had her boyfriend and her friend and the friend's boyfriend come over to the house. She falls asleep and she wakes up with the friend's boyfriend having sex with her. She immediately goes and tells her boyfriend what just happened. They remove him from the house. The offender, as he's brought out of the house, he denies having sex with the victim. The victim immediately calls the police. She goes to the hospital, has a SANE exam, which is a sexual assault nurse examination, where they take specimens from her and from her underwear. The boyfriend, the victim's boyfriend, has DNA taken from him, and basically he's excluded as a source of the DNA, which is found on the victim and in her underwear. And when the police the next day go to talk to the defendant, he says he denies having sex with the victim, says he wishes he did, and then says, when they say, well, can we have your DNA? He says no. What then happens is years of delay, such that by April 6th of 2010, the prosecution knew that to pursue this case, which the very day it happened, the victim identified to the police who did the crime and that it was a rape, but the people knew they needed the defendant's DNA. As of April of 2010, 38 months after the crime, they finally get a warrant for the defendant's DNA. And April of 2013, they finally get DNA results from the defendant, and it matches the victim, the sample from the victim. He's finally indicted on August 29th of 2013, more than 4 years after the crime. Goes to trial, and at trial, now that they have evidence that it was his DNA, that he was a source of the semen, he changes his defense from "I didn't have sex with her" to "it was consent." He's convicted. He's sentenced to 12 years jail. He moves and he appeals, saying they violated his constitutional right to prompt prosecution. The appellate division denies it. Goes to the Court of Appeals, and here we have majority and a dissent, and the majority says this did violate his right, and they vacate the conviction. Okay, and they what they do is they go through the Taranovich factors we talked about, and they say that the extended delay was inexcusable, 4 years, inexcusable. They can't account for 31 months of that delay, which is in the defendant's favor. And they say that the reason for the delay, factor 2, the people have no good excuse. And basically they say if number 1 and number 2, if the extent of the delay is extreme and there's no reasonable explanation by the people, that can be sufficient, even without any prejudice or anything else, to constitute a violation of the defendant's right to a prompt prosecution. And that's what they have here. They say number 3, 4, and 5 are not in the defendant's favor, but because number 1 and 2 are, it's a violation, and they dismiss the case. There's a dissent by Judge Singas, who's a former prosecutor, and she goes through a long history of rape in New York and the charges and the offense, how it's evolved over time, and that even as recently as 2006, they removed the statute of limitations, showing how important this crime is to be prosecuted. And when she goes through the Taranovich factors, she says, okay, yes, number 1 and number 2 fail, but number 3, 4, and 5 are against the defendant. And in her analysis, you are not helping anybody by letting a convicted rapist out of jail early when the DNA shows he committed an offense. And while the majority says, well, this is for society's benefit, to tell the police and the DA's office to do better, you're not really doing better for the victim and in general for showing that rape is important to the criminal justice system. And that's Too Long Didn't Read, People versus Regan. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.